Hello everyone, welcome to another edition of second Saturday for Sanchez Law Firm. I'm Benjamin Sanchez. I'm the owner and founder of our firm. We started this firm in 2007 and I've been practicing for over 25 years now. Today's topic is going to be evictions, specifically landlord-tenant disputes, evictions. In Texas, most of those evictions are residential evictions, so that is what we will be covering. Just to briefly start out by saying that for the most part in Texas, commercial landlords do not have to evict you. They have the option of a lockout. So if you are a commercial tenant, you have a small business somewhere, if you're behind on your rent or whatever, these procedures that we're going to go over today do not apply to you. The landlord can simply lock you out and y'all can try to work it out that way. There are some commercial landlords that do evictions just because they don't want to be accused of somehow locking you out illegally or whatever, but most of the time landlords will just lock you out. So today we're covering residential evictions, and those evictions are covered under Chapter 24 of the Texas Property Code. That is where you will find the eviction statutes that we're going to go over today, Chapter 24. Now, we're going to cover a lot of material today. In law school, some law schools will have a landlord-tenant class. Some law schools will just have a real property class and cover some of this in class. We cannot go over a full deep dive into evictions in 1 hour. I do want to leave some time to allow you to ask some questions. If you have questions, we do have someone monitoring the chat and they will let me know if there are questions. But we do have a lot to get through, and I do want to try to get through most of it before I start answering questions. So the first question is what type of evictions are there? In other words, what are the situations that allow you to have an eviction? I'm going to be using the board today for some of what I'm talking about. So the first one is going to be, you need to let me know if I don't know if y'all have well, not sure we're set up. Do you have headphones? No, you can hear me through here. You can hear me there.
You can hear them monitoring the levels. You can hear.
So we have a current tenant. That's the first type of one. We have what's called a holdover. In other words, you were a tenant, but now you're holding over beyond the lease. Then you have a former owner. You have a tenant. Of a former owner. And then last you have a trespasser or a stranger. So we'll be going over each of these. So when can a current tenant be evicted? Well, there are three types of situations a current tenant can be evicted. One is the failure to pay rent. In Texas, you can be 1 day late and the landlord can give you a notice to vacate. So a failure to pay rent on time is the first situation in which a tenant can be evicted. The second situation is when you have a non-payment of rent lease violation. So that may be the number of people you have non-tenants living with you who are beyond sort of the guest period stated in the lease. You may not be taking care of the premises like you're supposed to. A lot of times the leases will say that the tenant is responsible for the yard upkeep and things like that. So anything that's not a non-payment of rent that is a lease violation, you can be evicted for that. And then the other thing that most people don't really think about is when a house is condemned or it's a red tag, therefore making it uninhabitable. So I've had some tenants come to me who say, well, you know, I still want to live there, the landlord's kicking me out, but if the city or some government agency has gone by the home and red tagged it, by law, the landlord cannot rent that house. So the tenant must move out through no fault of the tenant, but if the house is deemed uninhabitable, then you must move out because it's illegal for the landlord to rent to you. So those are the three types of situations in which a current tenant can be evicted. The second one is when you have a holdover tenant. As you may know, that a lease is usually for a certain amount of time. There is no specific requirement in the law that says a lease has to be so long. It can be really short, it can be long. You can usually negotiate that with the landlord. However, most corporate landlords, the leasing managers are just following the guidance of the corporation, and so therefore they have standard 6, 9, or 12-month leases. I've seen some 13-month leases, so it just depends. But there's no minimum time, you know, really to do a lease other than maybe a month. So you have a holdover whose lease term has ended and it has not been renewed, and your ability to stay in the premises has been denied. Now I'll go over that in a little more detail because in Texas, when you have a renewal or when you go past the term, your lease then becomes automatic month to month based on the same terms of the lease. So if a landlord really wants you out without that renewal, they have to do certain things. They have to send you a certain notice to terminate your right of possession. Once they do that, if you stay beyond that deadline, then you're considered a holdover. You're not necessarily considered a holdover if the landlord has never given you that notice of termination of your right to possess the home or apartment. The next category is we have a former owner. This happens usually when we're talking about any kind of post-sale. So we have a foreclosure sale, we have an HOA who gets a judicial order to sell the home, and that home is sold, and you're still in the home as an owner. We also have the taxing authorities can go get a judicial order to sell the home, and then if you stay beyond that sale date, then you can be evicted. So whenever we have a post-sale, the owner who was once the owner is now no longer the owner. That owner can be evicted. We also have where the owner is him or herself not living at the property, but they've rented the property to a third-party tenant. And so when that house is foreclosed upon or it's sold via HOA or tax sale, and there's a tenant in the property, then that tenant can be evicted. That tenant does not have the right to stay for the full term of the lease just because they were on time with their payments and had a lease with the now former owner. And then finally, we just have, what I call a regular trespasser or stranger to the property, no connection to the property. That person can be evicted as well. Sometimes people will file a criminal trespass complaint. They may file a civil trespass suit, but the procedure of eviction is also allowed for people who trespass or strangers So those are the different types. Now, when we talk about these different types, they all start, in order to start the eviction process for everything but the we'll talk about the holdover. So let's just start there. So most evictions start with a notice to vacate. However, for the person to get a holdover, there's an initial letter called a notice of termination of possession. We do that for our clients whenever we represent a landlord. For the most part, we represent tenants. If we do represent a landlord, we do not represent corporate landlords. We do not represent multi-family unit landlords. So we'll represent a homeowner who has a second home or something as an investment. But those evictions must start with the notice of termination of possession. And then we give that person 30 days. We give them a full 30 days and say your right to possess this is terminating at the end of 30 days. Usually that arises because if you have a lease that ends without some sort of official notice of termination under Texas law, that lease then becomes month to month under the same terms as the original lease, including the 60-day notice. So let's say, for example, you go through a whole year and your lease requires a 60-day notice to vacate, or a 60-day notice that you're not going to renew. If nothing happens and you get to the end of that lease, then you're on a month-to-month. However, the 60-day termination clause still exists. So if you want to move out, you could still give a move-out notice saying you're not going to renew, but you don't have 30 days just because you're on a month-to-month. You have a month-to-month with the original terms, so therefore you're going to have to stay 2 months, or at least pay for 2 months, because that 60-day notice is still required to not renew. The same with the landlord. The landlord has to give you a notice of termination, and then your right to possess will end. So if both sides go through the entire lease and don't give each side notice, then it converts to a month-to-month on the original terms, and you are not in violation of the lease as a holdover at that point, because the landlord has not given you a notice of termination. So in those situations, either the landlord or the tenant has to give that notice. If you as a tenant give a notice and then you stay longer than what you anticipated, you are still considered a holdover, just as if the landlord had given you that notice. It doesn't matter who the notice comes from, but if there's a notice saying that we're going to terminate possession on a certain date, and you stay beyond that date, then you're considered a holdover. Most corporate landlords, again, while the lease is ongoing, they will send you a notice before the lease ends, stating we are renewing, or offering an extension to renew based upon these terms, or we are not offering an extension and you must leave by the end of your lease term. So it doesn't always happen after your lease is up. When you get through that part, for that unique situation, everything starts with the notice to vacate. The notice to vacate in Texas, there are 3 basically big time differences in these notices to vacate. There's a 3-day, a 10-day, and a 30-day notice to vacate. Now, the law does say, the Texas Property Code does say that a lease in and of itself can change the number of days. But normally most landlords will not seek an immediate eviction just because their lease says so. They'll try to honor these different days. I think it's best we stick with this. So when you're a regular tenant and you're being evicted, whether it's for a non-payment of rent or some other lease violation, normally your notice to vacate is 3 days. And I'll go over what a notice to vacate must have and what kind of form it is. We're just going over the timing right now. So your notice to vacate has to be at least 3 days. Now 3 days does not, unless the lease says that a prevailing landlord can't get attorney's fees for having to evict you. The law says after that kind of situation, then a 3-day notice to vacate does not give the landlord attorney's fees. The attorney's fees, if they want attorney's fees, they have to give you a 10-day notice to vacate. So they cannot, they have to give you at least 10 days to vacate for written notice. In addition, the attorney's fees language must be in the notice, so you must be made aware that if you do not move out in 10 days, that you will be subject to attorney's fees in a subsequent eviction lawsuit. A holdover is 3 days. A former owner who loses the home to a sale, that is 3 days. A tenant of a former owner is either 3 or 30, and then a trespasser or stranger that could be immediate or any timeline given by the landlord. Now let's talk about the tenant of a former owner who's lost the home to a sale. The reason why I say they have 3 or 30 days is because if they are current on the rent at the time of the foreclosure sale, or they pay the rent within 5 days of learning through a written notice of the sale with the name and address of the purchaser, and they make that payment within those 5 days, they are considered to be timely on their rent, and therefore they get a full 30-day notice under the Texas Property Code. If they're behind on their rent, and they, at the time of foreclosure sale, or they don't pay within those 5 days of learning about the foreclosure sale, then they are considered just like any other tenant, and they get a 3-day notice. So it's a very, very important. We have some people think that they're automatically entitled to a 30-day notice just because their landlord lost the home in the sale. But that's not true, because if you as a tenant are behind in the rent, then you don't get that protection of a 30-day notice. Because the way this works out is they're basically treating the tenant under a potential holdover, right? So the 30-day notice is really like that. The 30-day notice to vacate really kind of takes the place of that 30-day notice that you would normally have to end the lease, right, to end the termination. So that's why they give them that benefit. Otherwise, if the landlord could have kicked you out, the former owner could have kicked you out because you were behind on the rent or violated the lease under 3 days, then the new purchaser will be able to do that as well. It's important to know that the notice to vacate must be made by someone who is entitled to possession of the property. Now that person could be the direct purchaser, whether it be an individual or a corporate representative of some company, or it could be made by, some agent of theirs or an attorney of theirs. There has to be someone related to that. In other words, I can't go across the street to a house I don't know and send a notice to vacate and have that, have the tenants liable to an eviction suit because I have no connection to that property. So there has to be, and you would think that would come up, but that does come up where people who, most of the time it's a mistaken fact. They think they have the right, but they don't. Maybe there's some real estate dispute going on, but they didn't really have the right to evict you. And so let's say, for example, there's an agreement to purchase a house at some future point, but that purchaser never does anything to solidify that agreement. There's no closing on the sale of the home. Something goes wrong with that sale. The purchaser can't come and try to evict the current tenant because they have no right to possess that property at that point. So it's important that the written notice to vacate be made by someone who has a right or one of their agents or attorneys. For the 30-day notice we talked about, not only must you be timely and read, but you must have no other default. I think a lot of people get confused about that too, because if a former owner has lost the home and you're timely in rent, but you're otherwise violating the lease, and that can be anywhere from having guests stay over who are not named occupants on the lease longer than the guest period. So if you bring a cousin or a brother or a friend to stay at your home but they're not an occupant and they've been living there for a while, they're beyond the guest terms, for maybe 3 days or 5 days, you're in violation of the lease. So you want to make sure that you're not violating the lease when you learn of a foreclosure sale, because it's not just about possession, it's about violation. If you have a yard that you're responsible for landscaping and keeping up the mowing, you don't want to force a new purchaser to be able to kick you out because you haven't taken care of the yard. And those things can happen, so you need to be careful about that. The other thing we've seen is that when we have new purchasers after a sale, we've seen situations where the purchaser comes and knocks on the door and says, "I am the new owner, you need to get out." Well, knocking on the door, giving sort of a verbal notice is not sufficient under Texas law. They have to give you a written notice, and it has to have the name and the address of the purchaser. So, we have bully landlords in Texas, and sometimes, or we have people who just don't know the law, and they think that they can just come over to the home after they bought a home and just kick the people out. But people have rights, and so it's important that you know about those rights. The one situation where a written notice to vacate is not required is when you have a trespasser or stranger. So the law specifically says that the notice can be verbal or written, and it can be immediately to vacate or a certain period of time. So in this situation, we have someone on the property with no legal connection whatsoever to the property, and just basically strangers or trespassers. You can ask them to get out immediately, or you can give them a formal notice in writing. You can tell them, they got 3 days to vacate. It just depends on what the landlord feels like. But that's the only time a notice to vacate can be done verbally. I'm a little under the weather, guys, so you just have to bear with me for a little bit. Sorry about that, guys, but I didn't want to miss this for y'all, so I'm here. All right, the law allows for a notice of proposed eviction versus a notice to vacate. So, a proposed eviction is not a notice to vacate. So if a landlord sends you a notice saying, "I may proceed with eviction if you don't pay this amount by this date," okay? That in and of itself is not a notice to vacate. That's just a proposed eviction. So the law says that after the period that you're giving on this proposed eviction notice, the landlord still has to give you a regular notice to vacate. Now, the notice to vacate can say that you can either pay the rent by this date or move out, right? But that is a different type of language than saying, I may evict you if you don't pay the rent by this date. So you just have to really look at the notices. In Texas, the evictions are done under the law to be very easy and straightforward. A lot of the times when clients come to me, if I'm able to win those cases for the tenants, it's because I find a loophole or some defect in how the eviction was carried out. Whether they didn't send a notice of termination of possession, they didn't do the notice to vacate correctly. I just look at all the procedural mistakes and see if there's something that will allow me to win the case based upon a procedural mistake, and then make the landlord start all over again. So remember, the difference between a proposed eviction and a notice to vacate is that the proposed eviction doesn't actually tell you you have to vacate. A notice to vacate can just tell you get out, or it can tell you pay this amount of money by this date or get out by this date. If it doesn't say that, it just says we may evict you, then it's more likely a proposed eviction, and then you still are entitled to a notice to vacate after that. And just keep your questions for the end. I know I'm going over a lot. This is really a high-level dive because I don't want to get into too much minutia, but I'm trying to give you as much information that you can stay aware. The notice to vacate must be specific, it must be clear, and it must not be contradictory. So this is, the times I've seen this the most are two situations. The landlord either gets the address wrong about the premises, which, you know, if the landlord's doing it, okay, that's on the landlord. If an agent is doing it or an attorney is doing it for the landlord, then that can cause some problems with the landlord. But either the address is wrong, or the dates, they include dates that are incorrect. So if you're supposed to be given a 3-day notice or a 10-day notice or a 30-day notice, if you include actual dates instead of just listing the time, so most notices of vacate will say you have 3 days to vacate from receipt of this notice, and they'll leave it at that. Some landlords want to go further, just because they don't know better or whatever, but they may say, you have until, you know, let's see, this Monday is the 11th, so they may say you have until Monday, December 11th to move out. You know, if that date is within the 3 days, whether it's day 1, 2, or 3, then they haven't given you a 3-day notice. Let's say they also, instead they say, you have until Tuesday, December 11th. Well, then that notice is contradictory because Tuesday is actually December 12th, but you said December 11th. So which is it? So Tuesday, you know, might be have the 4th day, whereas, you know, the 11th is the 3rd day, but you don't really know. So you can have a defect in the notice to vacate. So that's what I look for. I try to look for defects. Now, usually those happen when we have landlords who are doing things themselves as opposed to hiring either an eviction company or an attorney to do it. But I do look for those kind of things. It must be clear and not contradictory. It can't say, you know, that I may file, you need to get out because I may file an eviction or whatever. Like we talked about the proposed eviction, really needs to be clear so whoever's reading it knows exactly what they need to do to comply with the notice, whether it's paying the rent or moving out by a certain day. The notice to vacate, it can be given in different ways. So we have, talk about this. The notice to vacate can be given by mail. Well, actually, let's do it. It can be given by personal delivery. And let's talk about that first. It could also be given by mail, then there's a third alternative. But what does what does personal delivery / in-person mean? One, it can mean directly to the tenant. So let's just say direct, in-person to the tenant. So, someone goes to the house, the tenant answers the door, and that notice is given directly to the tenant. And it can also be given to anyone who's 16 years or older at the home, who resides at the home. So, we have a resident, 16 years or older. Well, so why does that matter? Well, let's say that you have a son or daughter who's 16 or 17, and they have friends that come over. If the friend answers the door, who's 17, but is not a resident of the home, then delivery to that friend or that family member who's not a resident there is not sufficient. So if you don't give it directly to the tenant, then you must give it to someone who's a resident, but they have to be 16 years or older. So we gotta think about those things. You're having a party, you're having some friends over, you're having a sleepover. If someone else answers the door and they're given that notice, that is not sufficient for service of the notice to vacate. And then the last one for personal delivery is the inside of the main door. Now, normally this happens in apartment complexes as opposed to homes, but basically someone will go inside your home because they already have a key, and they can go inside the home, and then that front main, it's the front door, the front main entry door, not some side door, not the back door, well, the front main door. They can then post the notice to vacate, usually tape it to the inside of the front door. The legislatures, who developed this law basically said, look, if you're going in and out the front door, you're bound to see the notice on the front door. How have I beaten cases like this? It's because some people are just lazy, and they will put the notice on a table. They will put the notice on a counter. They put the notice, on the floor, whatever. But they won't actually put it inside the front door, even though the notice is inside the dwelling, and that violates the law. So if that happens, then I can ask the judge to dismiss the case because they failed to properly give the notice to vacate. So if this is in person, remember, personal delivery is either directly to the tenant, a resident who's 16 years or older, or inside of the main door. Those are the three ways you can do it under the Texas Property Code. The next one is by mail. You see this more times with a home as opposed to an apartment, but it can happen in an apartment. With mail, you can have, believe it or not, you can have regular mail, registered, or certified. You would think in this day and age that the law would ban regular mail because there's really no proof, right? So this would be if a landlord takes a chance by doing it by regular mail, then there's going to end up having to be some testimony at the trial that is happening, that the notice of vacate was sent by regular mail. Certainly most landlords in this day and age will do certified mail instead of regular mail. Registered is out there, but hardly anyone uses it. Really, certified mail should be the default for any mail. Okay, so that is what we have for the personal delivery and mail. I hope y'all are getting this written down, because I do go over it. So the next one, so there's an alternative under the Texas Property Code. The alternative is based upon the fact that the front door may not be, or it may not be safe to go inside the front door, or let's say the locks have been changed by the tenant, so the landlord doesn't have the key and can't go inside the front door. So the law says that, if you fear for your life that going inside the home to post inside the front door, or approaching the tenant directly, or approaching the house is somehow going to endanger you, it does give an alternative if you don't want to do the mail. Really, quite frankly, the mail would be the best part, but some landlords do this, is you can post on the outside of the door. Again, I know quite the logic, because if you're afraid of going inside the house, you might be afraid of even going up to the door. But that is the law. There's also something else, we'll go over this one at a time. So, what must the posting on the outside of the door, because remember we also have sort of privacy rights, and you can't, whereas on the inside of the door, you can just post the notice itself without some envelope or anything, because it's private, it's inside your home. On the outside, it's no longer private, so mailman or someone comes up to your door, the law says they can't see just a whole notice to vacate. So the posting on the outside has to be done so the notice to vacate must be inside of an envelope. The envelope must be sealed, okay? So that way you'll know if the seal has been broken. On the outside of the envelope, it must have the name, address, and it must have in all caps the word important document. So remember, it must have the name, address, and important document to the seal on the front of the sealed envelope that's attached to the outside of the main door. Then second with that, secondly, you must mail the notice to vacate to the same notice to vacate that's inside the envelope. That must be mailed the same day by 5 p.m. It must be put in the mail by 5 p.m. What's important is that mail has to be put into the post carriers, the U.S. Postal Service, in the same county as where the home is located. So, for example, if you have a local person putting the posting right on the outside of the door, but you have a corporate office from New York or Los Angeles actually mailing out the notice, then that alternative has not been met. So normally what happens is the person who's posting is also the one who's mailing, because they're already in that same county. But it's important to save whatever notices and envelopes you get in the mail regarding notices to vacate. Because if the postmark shows it's not from the county in which the notice, in which the home is located, then that is another technical way I can defeat the notice to vacate, or you can defeat the notice to vacate in court. So remember, posting on the outside of the door, the notice to vacate is inside. The name, address, and the words important document in all caps on the outside. You must mail that same notice by 5 p.m. the same day in the same county. And just a reminder, the notice to vacate can tell you that you must pay rent in addition to the vacate, right? So it may state that you can pay the rent by the third day or vacate. That is a valid notice to vacate. Okay guys, now we're getting to the eviction suit. So the notice to vacate or the notice of termination followed by the notice to vacate has been done. And now there is a notice to sue for eviction. What's really important here, guys, that is a big question sometimes that I have to deal with in eviction cases, because sometimes my clients do not move out by the third day or the 10th day or the 30th day. However, the landlord doesn't sue right away. And so the question is have the tenants moved out before the eviction lawsuit is filed? If they have moved out, then the eviction lawsuit is invalid. Because the only reason to file an eviction lawsuit is to regain possession of the premises, and it's presumed that the landlord will have possession of the premises whenever the tenants have moved out. Now, there may be rent owed, but if the tenant has moved out and there's still rent owed, and the landlord wants to go after the rent, and that is simply a small claims case in which you're suing for the rent because it's basically a breach of contract. You do not have a possession lawsuit. So remember, eviction is about possession. In Texas, they allow you to add the past due rent, the unpaid rent, as part of the possession suit, but the eviction suit is all about possession. And if you have moved out before the eviction lawsuit is filed, then that lawsuit could potentially be dismissed by the judge. So I always try to find out, especially if the tenant has already moved out, when did they move out? Did they move out? I look at the date it was, the eviction suit was filed versus the date my tenants tell me they were out, and we try to go from there. Now, what does move out mean though? Because in Texas, we have such strong property rights that if you yourself are physically moved out, but you still have possessions in the home or the apartment, then you are still considered in possession of the premises. You're still considered in possession of the property, because we don't want landlords just coming in whenever they feel like it and taking all your stuff. So there's a couple things you have to deal with. One, if you have moved out and you're not going to take anything else with you, and you just run out of time, you don't want it, you don't have the expense or the manpower to move it out or whatever, then you need to let the landlord know in writing that you have moved out and that you have abandoned whatever personal property is in there. Okay, so if you give the landlord a notice that you have moved out and you've abandoned the property that's still in there, and you do that before the eviction lawsuit is filed, then you will still be considered moved out, even though you have personal property in there. If you do not give that notice, then if the lawsuit is filed and you haven't told the landlord and you moved out and you go to court and say, but Judge, I was out. Well, if you left appliances, personal property, whatever, in the home or the apartment, then you're still considered in possession and that eviction lawsuit can go forward. So make sure that you either move out completely or anything that's left behind, that you give a notice of abandonment of that property and that you moved out. What can a landlord ask for in an eviction lawsuit? The eviction lawsuit can ask for possession. That's the primary purpose of an eviction lawsuit. It can ask for unpaid rent. It can ask for attorney's fees and court costs. That's it. So some landlords try to include the fees that they've charged over, the months or years, whether it be late fees or other types of fees. Those fees are not allowed in an eviction lawsuit. I've seen many times where a landlord representative goes to court and tries to prove up all this, and then the judge asks, well, how much of that is actually rent? And if there's some amount that's less than that's actually rent, then the judge is only going to give that rent, not the extra fees. What's important though is this. Where this comes into play sometimes is that a landlord can keep a running account of your past due rent and the fees that they charge. And then the contract can say that we apply the payment of whatever you pay to the oldest amounts due. So in other words, if you have late fees or whatever, and those are still due, and you go in and you're thinking you're paying current month's rent, the landlord can take that money and apply it to the old late fees and all this other stuff. So therefore, you have not actually paid the current month's rent, and you're not current. So you have to be aware of the landlord's accounting and how they account for your payments. Even if you say, I'm paying for the current month's rent, if their contract and lease says they can apply it, then they can apply it. If you dispute that, then you may need to do a formal dispute, and if worse comes to worse, you may have to go to the small claims court yourself and dispute that. But a lot of landlords will use that accounting system, and they'll take this money that you think you've been paying for rent, and it keeps going back to all the other stuff that you owe. And then guess what? So now you think you're current on your current month's rent. It's been applied to other things. Now they hit you up with more late charges for the current month, even though you thought you were done. And then you go to the next month, you pay current month's rent. They apply it to old stuff. Guess what? More late charges occur. So you have to be careful about that. Another thing you should know about the eviction lawsuits is that even if you leave after the lawsuit has been filed, so therefore you're no longer in possession, the lawsuit can still continue for the unpaid rent. More likely the judge will give the landlord still possession, just to be safe, and give them rent. So just because you move out after the notice, after receiving, actually let me back up. So you may not get notice of the lawsuit, you may not be served for a while. But the rules, the Texas Property Code says it determines at the date you file it. So, let's say this is a file date, we'll make that day 1. And this is service date, we'll make that day 10. So you got the file date or the service date. Now this move out before the lawsuit is filed, that's determined by the file date. So let's say you didn't even know about this lawsuit being filed, and you move out day 5. Okay? Just because you weren't served yet doesn't mean that you're good to go, because you moved out after the date it was filed. So you have to move out before the file date in order to make that lawsuit go away for eviction. I'm going to cover just a little bit on appeal, and then we'll open up to questions. So, whoever loses the eviction lawsuit has the right to appeal. In the judgment, the judge must state what the appeal bond is. Normally that is twice the amount of the judgment. So if you get a judgment for $5,000 against you for unpaid rent, then, and attorney's fees or whatever, then the appeal bond will be $10,000. Now, there are not a whole lot of bond companies that do eviction appeal bonds because obviously they're dealing with someone who's been accused of not being able to pay their bills. So most bond companies need some type of surety. So normally a court will take a cash deposit in lieu of a bond. So if you have somebody that can loan you some money or whatever for $5,000, or you have it and you can pay that to the registry of the court instead of the bond. If you don't have that money, can't get access to it, then you can file a statement of inability to pay appeal bond and court costs. All Texas JP courts are required under the property code to have that form available. It's not a form that you have to think of and create. When you file that, when you prepare that statement of inability, that acts, and you file it, that acts as your notice of appeal. All that has to happen within 5 days. If you miss the 5-day deadline, then a writ of possession will be issued by the court, and a constable can go out and then get you out. To cover that real quick, if you do get a writ of possession issued against you, what happens is that goes to a constable, not a private process server. The constable then normally will go to your home and leave some sort of notice on your door saying, hey, I've got a writ of possession, I need you to get out in the next 24 hours or be subject to me coming back out and forcibly removing you. The law does not say that the constable has to do that. Most constables don't want to go through the work of actually having to kick someone out, so they usually send that notice, hoping that the tenant will move out on their own or whatever. But the law says that a constable can't just show up at your door with writ of possession and kick you out right then and there. Okay, they can leave your stuff on the street. They don't have to store it. They just have to leave it somewhere off the premises, so they can take it. And it's not a matter of like putting it in the yard, right? Because that's still on the premises. But they can literally go in. They don't want to do moving or whatever. Just put it on the street. Most of the time, landlords will make some moving company available to then go take that stuff. But that's again more corporate landlords, more people who are doing it by themselves. They can just put it on the street. Constables aren't really going to be the ones picking the stuff up and moving it out. They're there to keep the peace and make sure that the stuff does get moved out. If you do appeal timely within those 5 days, you can appeal by either paying that cash deposit or the statement of inability. If you do the statement of inability, you have to pay 1 month's rent into the registry of the Justice Court within 5 days of the statement of inability being filed. Okay? If you don't do that, if you file that statement of inability but don't pay that first payment, then you can you'd be considered in default, and then your appeal won't go anywhere. There's a whole lot of stuff that happens for appeal. I don't really want to get into too much because otherwise I'll just be going by real fast. But what basically the appeal allows the county court, because it goes up to a county court, it allows the county court to have a new trial in your eviction case as if the JP court never happened. So whatever happened in the JP court doesn't matter. JP courts are not courts of record. They don't have a court reporter. They don't have a transcript of what you said. When you go into county court, the judge is not going to care that the other side said this or that in JP court because there's no record of it. So you can't say, well, they admitted in JP court this or that or whatever. It's just a new court. The rules of evidence and rules of procedure apply in the county court, whereas normally they don't apply in JP court. So you just got to be mindful of that, what you need. The last thing I'll say is this. What must a landlord have to prove an eviction? One, One is that they have a superior right to possession. It may be a lease, it may be a deed, but they have to show a legal right that they have a better right to possession of the home than you do. So in other words, I can't go in and file an eviction lawsuit on someone else's property if I don't own that property or I don't represent the landlord. Just makes sense. I can't go evict people out of their homes when they're strangers to you. The next thing is they have to show a notice to vacate. They have to show that they have to prove the notice to vacate. They have to have it before the court, and they have to, unless it's that stranger trespasser where you just told them to get out, right? That one doesn't matter. But here you have to show the written notice to vacate and also how it was delivered, right? So you have to have the what, how, and when. Remember, when on the notice to vacate, what the letter says, how it was delivered, and when it was delivered, all those matter when you try to prove up your eviction in court. And then the last thing is that the tenant is either still in the premises and or rent is owed. So, sometimes tenants think they can get out before trial date and they won't get an eviction. As I said before, that won't matter as long as you still owe rent. The unique situation is if you're sued for a non-payment of rent violation, okay, then you get out. And you're already paid up, right? So your rent is actually already paid up, and you get out. Well, what does the judge have to decide at that point? Because you're out, the rent's paid up, there's no ongoing violation of the lease. Most of the time, a judge will just simply dismiss that case. I have seen judges say, well, just to be safe and sorry, I'm going to give you possession because we don't know, if there's personal property still in the home or whatever, right? Because a lot of times those kind of tenants don't even show up to court. So the judge still gives a judgment for eviction to deal with the issue of the premises or whether there's any personal property. Now this has sort of been a quick but deep dive into evictions. We have a few minutes left. I'll go over to answer the questions. Do we have any questions?
We have 2 questions from Angie. She said, hello, what do I need to do if my father passed away and I need to change his home, which he was renting, to my name? I was the person paying his taxes and the person taking care of him due to his sickness when he was never...
So let's just talk about this. Generally, we're talking about an heir taking over a home that the father had passed away. That doesn't go through straight to eviction because the person who takes over the home is not necessarily would pay the taxes or pay the home or whatever, is not necessarily the person who has a superior right of possession. But usually there's some sort of probate process. You establish a probate, you go file it, then once the probate court establishes your right to possess, then you can use the eviction process to then kick out the tenant. Now, you don't have to wait until the probate process is over. So normally what happens is if there's a will, then the executor represents the estate while the probate is going on. Once the executor has been appointed by the court, then that executor can send the notices out and do the eviction lawsuit, whatever, in the estate's name. So you can do it that way. Or you can just wait until, if you're going to get the property through the probate, you can wait till you actually get the deed that puts it into your name, and then you yourself, separate from the estate, can then go do what you need. But you can't use the eviction process without having some sort of authority, and that authority is going to be derived from some sort of probate process. Sometimes there's an affidavit of heirship. I still prefer people to use the probate process so that they have some sort of court order that says this person has a right either by being, the executor or the administrator of the estate, or they've gotten a will through some sort of deed through the probate. Yes, next one.
If you are renting a home, is it mandatory to have home insurance?
So if a home is being rented, homeowner's insurance is not required. The question is if you're renting a home, is it mandatory to have homeowner's insurance? If we're talking about insurance for the home itself, that is not required under Texas law. Normally mortgage companies want you to have insurance because, that's the security or collateral for the loan. So mortgage companies require you to have homeowner's insurance as long as you're paying on the loan. If you're the tenant does not need to have homeowner's insurance that covers the home. However, the question then becomes, is there renter's insurance? Is that required? That is not required by law, but most, some landlords, especially the corporate landlords, will require you as part of the lease to show proof of renter's insurance for the contents. And that is just a contractual thing. So you can try to strike that out while you're negotiating the lease, but if they require you to do it, then that's a contractual thing. But by law, insurance is not required by law.
If late fees or penalties are specified in the lease and also agreed to in the landlord rules, will the judge include these in the final settlement?
So the question is, if late fees and other charges are in the lease, will the judge add those to the final judgment? So I think the question referred to settlement, but the judge doesn't do a settlement. It's just a judgment after trial. The judge, by law, cannot include those, right? So no matter how much those fees and other charges are, the Texas Property Code says only three things are in the judgment. The late fee can be the unpaid rent, the attorney's fees, and the court costs. Anything else, no matter how big, not included in the judgment.
If tenant vacates and leaves possessions and does not send a notice to the landlord of abandonment of personal property, what is the recourse for the landlord?
Well, if the question is, if the tenant leaves and doesn't send a notice of abandonment and still leaves things in the home, what's the recourse for the landlord, or what's the landlord's recourse? I mean, obviously they can proceed with the eviction because they believe that, there's still proof that the tenant is in possession because they have personal things. So I would say that the eviction can still go forward. The tricky question is what do you do with the possessions? As an attorney, I always want to do like the most conservative thing. So I would advise the landlords to, if they know the address, they can send a notice and do some storage of the possessions for 30 days and say you've got 30 days to come pick up your possessions, or else they'll be these possessions will be sold or destroyed, dumped or whatever. If you don't know where the person has gone, then I would keep the possession stored while you go through the eviction process until you get a final judgment. So let's say the tenant leaves, but then it doesn't show up for JP court, okay? And then within 5 days, the tenant decides to file an appeal, like all of a sudden, because they got a default against them, and that happens all the time. Tenants know they have a right to appeal, so sometimes they don't even bother with the JP court, and they wait till they can appeal, and then they go to county court. So that process may take a while, and you don't want to distort things while there's a legal process going on. If you get through all the final judgments and all the appeals, then I think at that point you can you're free to destroy them or sell them. No, you can keep the money, or you can keep maybe the expenses of having to sell them, but then you have to deal with keeping the money for the tenant that's left over. But I would not get rid of the possessions until you have some sort of final judgment.
Can a landlord lock you out after the notice to vacate and before filing an eviction lawsuit?
The question is, can a landlord lock you out after the notice to vacate and before the filing of an eviction lawsuit? The answer is yes. However, the lockout rules state, unlike in Texas where, unlike sort of in commercial cases where they can just lock you out and that's it, in residential cases they have a right to lock you out, but they also have to give a notice on the front door that says, we changed the locks, here's my number, and call me, and they have to give you a new key. They can do that within 2 hours, okay? So really the lockout is sort of a wake-up call under the law as opposed to like a permanent remedy. So they can't necessarily just say, oh, you're locked out and you got no remedy and screw you. They have to give you the opportunity to get the new key and still have that legal proceeding. But some landlords will do it sort of as a wake-up call and say, hey, I'm really serious. I gave you that notice. Now I'm locking you out. Here's the key, but you don't move out on file.
How can you get a wrongful eviction removed from your record?
How can you get a wrongful eviction removed from your record? The eviction judgments are judgments. They're public record. You can't, in the United States, you can't somehow get a judgment like totally removed unless you go through this other process called a bill of review. So if you get a wrongful eviction because you weren't given notice or whatever, you have to file this new case called bill of review in the same court where the eviction was, and then you ask the judge to have that judgment overturned or vacated. If the judge grants the bill of review, all that does is it takes the original judgment, the eviction judgment, basically throws it away, and then reopens that original eviction case, right? So then you have to proceed with the eviction case. If the judge denies the bill of review, then the original judgment stands, and that's where you're at. But if you got so that's a wrongful judgment. Sometimes people ask me if can they remove a judgment after so many years or whatever. You can't do that. So if it's a good judgment or it's too late, so there are some time limits on the bill of review. If it's too late to file the bill of review, then you're sort of stuck.
What is the point of penalizing a tenant for late payments in the lease if the judge won't enforce? The TREC lease provides these penalties.
Right, so, that's a matter of contract, but the law doesn't, the eviction is supposed to be a quick and easy process for the landlord to regain possession, right? It's not a case about fees and all that. So it doesn't mean that you can't go after those fees, in a small claims case. It's just that in an eviction case, so the landlord's actually lucky, if you think about it. So I know it doesn't seem that way, but in an eviction case, the eviction case is all about possession. The Texas law just says, well, in addition to the possession, we'll let you go ahead and collect the unpaid rent because at least that should be provable without a whole lot of people fighting over fees and charges. If you want the fees and charges, then you can file a separate small claims case, or if it's too many, you can file a case in whatever court, but you can file a separate case for those late fees and other charges. It just won't be part of the eviction suit for possession.
So this is not a question, but I'm kind of putting it to a question. So the person said, I was evicted out of my home 3 years ago. What if this person just realized that the landlords violated the eviction process? Would she be able to do something?
So the bill of review, so someone's asking if they were evicted 3 years ago and just now realizing that maybe the landlord didn't do it correctly. The bill of review that I talked about, that timeline is based upon when you found out about the eviction, not when you realized that they did something wrong. Now the good thing in Texas is the bill of review is up to 4 years. So within 3 years, you still have the right to file the bill of review to try to overturn it. But then again, that would just reopen the original eviction. I've had some landlords just don't want to mess with it at that point. So when I file a bill of review, they'll just agree to it, and everyone move on their way. But you you do have that recourse of up to 4 years to file a bill of review. But again, it's from when you found out about the eviction, not when you realized something was wrong about the eviction.
So that same person said that she was evicted from her home 3 years ago based on fraud. She also said that she is the owner of the property, and I asked her who evicted her, but she has not responded yet.
Well, if someone's giving us a particular fact pattern, if you've got questions, you can call us. This is not really meant to be a case-specific dialogue. Anything else? So, ladies and gentlemen, I hope that this eviction webinar, this sort of quick deep dive into eviction has been helpful. We are also doing, we'll be doing these on the second Saturday of every month. Next month, we are going to be focusing on the awful, dreaded HOAs and those disputes that homeowners have with HOAs. Again, that topic can cover a lot. I'm going to try to give you the highlights of what most homeowners and HOAs should know. And then we'll do a question and answer after that. We're going to try to develop a schedule for at least the first 6 months, if not the first year, the entire year, by the time we come back to you, so we can give you that information. We are Excellence in Action. We do not only represent our clients, but we also try to educate the public and help you learn your rights. We are a Texas consumer law firm. We also handle real estate litigation, and we look forward to seeing you again next month. Until then, be safe and have a happy holiday season. Thank you.